Mr. Nduna. We welcome you back into the interview room. I will ask you, the first question is in two parts. The first part is as follows. What is the effect of a declaration of constitutional invalidity of any law by the High Court in a constitutional application? And the second part, state any two procedures by which an order of constitutional invalidity or validity by the High Court may be brought to the Constitutional Court for determination.
Thank you, CJ. Good afternoon. I'll address the first question, the first part of the question, which requires me to articulate on the effect of a declaration of invalidity by the High Court. When the High Court declares a law as invalid, that declaration will not take effect until it has been confirmed by the Constitutional Court. If the Constitutional Court confirms the declaration by the High Court, it then takes effect. If it is dismissed, then the law therein concerned remains in force. Thank you, sir. Then I'll proceed to the second part of the question, which requires two procedures through which a declaration of invalidity will get to the Constitutional Court. The first one is an automatic procedure, which is generated by the registrar, who is required by the relevant procedure to ensure that a record touching on the matter is submitted to the Constitutional Court within 14 days of the said declaration. The second procedure is whereby an interested party may launch an appeal to the Constitutional Court emanating from the order of declaration passed by the High Court. CJ, those are my answers to the question.
The second question is also in two parts. The first part, what are the exceptions that must be taken into account by a court when deciding whether or not to grant specific performance in a contractual dispute? And the second part, what is the test which a court applies in the determination of an application for absolution from the instance?
Thank you, Honorable CJ. Specific performance is regarded as the default remedy where there is a contractual breach between the parties. Therefore, the question requires me to address instances where the court may not grant an order of specific performance. The first one is where there has been what is referred to as a vis major, that is an act of God which will have been intervened to render performance as agreed by the parties in their contract impossible. Attached to that exception is, so in such an exception, in such a situation, the court may not then grant an order of specific performance. However, attached to that is whereby the parties may have anticipated the occurrence of such an event, which I have alluded to earlier on, and may have made some clauses to cater for that eventuality. In the event of that, then a specific order of performance will then be granted in terms of the clause of the contract which the parties will have foretell in the agreement. The next exception I would want to relate to is whereby the contractual clause requires performance to execute an illegality or contrary to public policy and to the law. The court will not aid parties in that respect by refusing the grant of an order of specific performance. I think I'll end there with the first part suggestion. I'll proceed to the second question, which calls for a test. I'm sorry, suggestion, if the second part may be repeated for my benefit. The second...
The second part.
Yes.
Right. The third question is in 3 parts. The first part, state any 2 components of a sentencing judgment.
Sorry, CJS, I said if I can have
Sorry?
The second part of the second question, the second part rather than passing.
What do you want? You want me to repeat it?
Thank you, sir.
Yeah, please speak loudly so that we don't make a mistake. It is as follows. What is the test which a court applies in the determination of an application for absolution from the instance?
Thank you, CJ, sir. Yeah. I'll start by addressing the stages where abolition from instances can be applied for. Firstly, it can arise at the closure of the applicant's case or the plaintiff's case, where the other party will allege that the plaintiff may have not placed evidence to establish the cause of action at all. Therefore, in such a situation, the court will evaluate the said application in view of the evidence received, whether the cause of action has been established. When it agrees with the plaintiff, then abolition from the instance will be granted. So the test is whether or not the evidence placed by the plaintiff before the court established all the essential elements, if I'm to speak of the cause of action, which forms the basis of the claim. Then in the second instance, abolition from the instance can also be granted at the closure of the defendant's case if both parties have not made up evidence which entitles either party to a judgment of the court. In such instance, an abolition of at the instance will be granted, which would be like there would have been no litigation at all between the parties. That's my answer, CJ, sir.
Question is, as I said, is in 3 parts. The first part, state any 2 components of a sentencing judgment. And the second part, how does a sentencing judgment under the sentencing guidelines, regulations, differ from the previous practice of giving reasons for judgment? And lastly, what is the role of the victim impact assessment statement?
Thank you, Honorable CJ, sir. A sentencing judgment was brought into the jurisdiction in criminal law through statutory instrument 146 of 2023. It has a number of components, of which, as requested, I will address two of them. The first part is the introduction, wherein the court is required to state the law, the charge upon which the accused has been convicted. It may also be necessary in that component to state the address of the accused persons, so that the audience of the court will appreciate the charge with the person who has been convicted and upon which charge he has been so convicted. The second component is that it must contain and clearly bring out the plea tendered by the accused person. I'll proceed to the second part of the question. The question requires me to enumerate on the difference between the sentencing judgment presently in place in this jurisdiction to the previous reasons for sentence. Like I said above, a judgment, a sentencing has a prescribed structure which must be followed by a court, wherein it has distinct parts which assist the court to address all issues which might have arisen which affect its sentence. The next difference is that the reasons for sentence, the courts would adopt any format which it deems fit, which answers to the individual court's personal interests.
Mr. Nduna, you seem to be reading. Have you written, are you having written
No,
answers?
I'm trying to check whether I'm addressing the,
Can you just check
question.
It's actually just questions.
Sorry?
Actually just questions.
Oh, it's just scribbled the questions. All right. All right, you may proceed.
Thank you, Honorable CJ. I had said that for reasons for sentence, the courts were not guided, so to speak. In other words, the court will adopt any structure which answers to his or her test. Therefore, in that drive, it would fail to be as elaborate as we get in the statutory sentence judgment. I'll proceed, sir, to the role of the victim impact statement. A victim impact statement is primarily meant to inform the court the effect of the crime upon the victim. Therefore, it entails the identification accurately of the victim of the crime, who then will be involved in the drawing up of the victim impact statement, so that if there are any reparations which may accrue to the said victim, his or her concerns will be adequately taken into account. Thank you, Chief Justice, sir.
Then the fourth question, which also has two parts. The first part, how have the High Court Amendment Rules 2024 addressed the key concerns of access to justice on the IECMS platform? And the second part, state 3 ways in which the IECMS has revolutionized civil litigation in Zimbabwe.
Thank you, Honorable Chief Justice Sen. The 2024 rules referred to are embodied in statutory instrument number 81 of 2024. These were promulgated to address what may have appeared to be gaps in the legislation, which was then repealed, being substituted by the SI 81 of 2024. Firstly, what this amendment does is to expand the time within which the filing of documents onto the ICMS platform will go hand in hand with the use of hard documents, that's hard paper copies. It also allows the court's discretion to either, in view of the demands of the justice of a particular case, whether it is to be held on the virtually or through physical appearance. So in other words, this enabled justice to be opened to all parties who want to access courts. And the second requirement which was brought in was also the establishment of e-filing offices in courts across the country, which is now mandatory upon the Judicial Service Commission to ensure that there is and there are e-filing offices across the country. But however, I would again hasten to add that even prior to the coming in of this piece of legislation, such offices had been established across all courts in this country. I'll proceed, CJS, to the last part of the question, which invites me to state 3 ways in which the integrated electronic case management system has revolutionized civil litigation. As I've said, the drive, the vision of the Judicial Service Commission is to create a Zimbabwe in which world-class justice prevails. This is achieved by the quick disposal of cases. And the ICMS comes hand in that it offers a continuous monitoring of all facilitators in the civil justice system to ensure that no one sleeps on the job, so to speak, so that action is taken as and when it is due. This then will improve the disposal rate of cases, thereby expanding the concept of access to justice, which was sort of limited before the incoming of the integrated electronic case management system. The last but not least of the 3 ways is that now the processes which will have been uploaded onto the integrated electronic management system is safeguarded and cannot be illegally or improperly accessed, thereby insulating court records and processes from illegal destruction by delinquent parties. So in other words, it has made the processes highly secured and preserved so that the stories of lost records or lost pleadings is now a thing of the past. Thank you, Chief Justice, sir.
Yes, thank you. I will now hand you over to the other commissioners for further questioning. Yes, CJ.
Yes. Thank you, CJ. Good afternoon, Mr. Nduna.
Good afternoon, ma'am.
I have one question for you. We have information compiled by the JSC suggesting that there's been a number of complaints over the years of different forms against you, but I'm going to zero in on one. This information is alluding to a 2018 letter of complaint written by the lawyers of CBZ Bank, and it was to the effect that the letter was to the effect that you had taken a loan, an overdraft of over $30,000, but that you were refusing to pay it back. That summons were issued, you raised the defense of prescription. What then happened thereafter? Is it true that you did not pay back the loan of $30,000 US that you took from the bank?
Thank you, Madam Commissioner. Indeed, it is true that I entered into a contract with CBZ. It was a farming contract where they advanced the said $30,000 as part of their performance under that contract, and that money was not eventually paid back, and it was not paid back. Yes, ma'am. And their letter of complaints, unfortunately, did not put clearly what led to that position. If I'm allowed to elaborate, ma'am.
Sorry, what position are you talking about?
The non-payment of the particular loan. What led to that? And the
summons was it true?
Yes, I
You
answered.
took a loan, you failed to pay it back. That's what we want to hear from you.
I took a loan, ma'am. True is true, and the loan was not paid back.
Yes. And then when they eventually tried to sue you, you raised the plea of or defense of prescription. So our concern, or my concern, is that you took a loan that you failed to pay back. Is that conduct that one would expect from an aspiring judge of the High Court? Failing to honor agreements, or an agreement that they freely entered into, and then hiding behind the law, blaming the lender for not having taken you to task earlier to recover their money.
What led me to the non-payment of that loan were the circumstances which were created by the bank itself, which of course they then delayed to make their claim. And
The issue is not them making the claim, Mr. Nduna. The issue is, why did you not pay back?
Thank you, ma'am.
You don't. When you enter into an agreement, it doesn't say you will not pay until they make a claim. It says you undertake to pay back.
Thank you, ma'am. Like I have said, that this was a contractual agreement where CBZ was supposed to perform in order to place me in a position to pay. Like that particular contract was a farming agreement whereby CBZ was supposed to fund the farming, providing all the inputs which could lead me to produce enough produce from which then the loan was going to be payable. But unfortunately, what CBZ then did was that they failed, among other things, to provide me with nitrogen fertilizer, which was, in my view, a material breach of the contract, which then disabled me from producing that which was enough to pay the contract. And I had engaged the bank before the time to pay the contract was materialized, bringing to their attention this fundamental breach to that contract and explaining that in the absence of their performance, it was going to be impossible for me to repay them, because in farming where nitrogen fertilizer is not applied, you literally get nothing.
I don't think the Commission wants to hear all those details.
Thank you.
The bottom line is that there was a loan that you took that you failed to pay for whatever reason, in circumstances where you could have taken some type of action if they were breaching the contract. Instead, it seems like you waited for them to claim the money back from you. Thank you.
Yes.
Thank you, Chief Justice. I do not have anything new, but I just want to follow up on the issue of the CBZ loan. To be honest, I'm very shocked that a judicial officer would use a technicality to evade payment of a debt. If it is proven to be true, I don't think that should make you suitable to be considered to the office that you are aspiring. In addition, you are also accused of using inflammatory language to a witness. Are you aware of the incident involving a senior government official and the subsequent complaint that you used inflammatory language? Something again that I believe is not befitting of the office of a judge. Now, having made those observations, my question to you, Mr. Nduna, is do you think a judicial officer should in any way be associated with such conduct?
Thank you, Madam Commissioner. I would acknowledge that there was a complaint which was raised when the senior civil servant appeared before me as a witness. He was of the view that inflammatory language had been used, and a letter was delivered to the Judicial Service Commission, which eventually got to me. And whilst I agree that those sentiments had been used, the environment in which those sentiments were uttered, so to speak, were that it was a situation where I thought I was trying to administer the case in a manner which would have achieved justice in the manner which was appearing before me, where the senior civil servant was testifying. So it was unfortunate and regretted that it turned out to be so, and I would rest on the history of my management of cases that such a complaint had not at all cropped up. Not that people did not complain, but the manner in which my communication with that witness was perceived never arisen during the course of my work as a judicial officer.
Lastly, on section 4 of the general forms that you were filling, you filled in Sorry. On section 4 of the general form, you just indicated that it's not applicable, where the question was, are there any circumstances, financial, political, social, or otherwise known to you which may cause you embarrassment in undertaking the office of High Court Judge? Don't you think you should have written something along those lines rather than saying non-applicable? Does that demonstrate integrity on your part as an aspiring judge, Mr. Nduna?
Thank you, Madam Commissioner. On hindsight, I feel I should have adverted to that. But when I was compiling that form, to be honest, it did not cross my mind that it is intended to extend that far. And I admit I may have ignored a salient point, not out of dishonest, but not appreciating, as it were, that I should have disclosed that.
Thank you, Chief Justice, and good afternoon, Mr. Nduna.
Good afternoon, sir.
I have one question for you, but before I do so, and for the comfort of my mind, I need to revisit the CBZ issue. What I wanted clarified is the Commission to understand that this matter was resolved on the basis of the success of your plea of prescription, that there was no further inquiry, so the matter was resolved on the basis of prescription. I know that we have explained that there were all these other issues and so forth, but for our purposes, are we to understand that this matter was resolved on the basis of you raising that plea and it was successful?
Thank you, Commissioner. The plea of prescription was raised as a special plea. We had also pleaded over raising the issues which I have adverted to over the non-performance of the obligation by the other party in the contract. So after we had submitted that, the bank did not take its matter further, but then dealt with it through the complaint procedure with the employer, the Judicial Service Commission.
I see. Thank you very much. So, in other words, the matter died at that stage?
I would confirm that since I received no further communication from the bank.
Thank you very much. Now, to my question. What are the three recognized categories of precedent in our jurisdiction?
I'm sorry, Commissioner, come back again.
Okay. What are the three recognized categories of precedent in our jurisdiction?
I'll attempt to answer the question, but only to one instead of three, because what comes to my mind, which I suspect comes correctly, is that precedent, the categories, that of the decisions by the higher courts, which are binding on the lower courts, is precedent. I cannot finish the other two. May they pass.
Thank you very much. Thank you, Mr. Nduna. Thank you, Chief Justice.
Yes, thank you. Yes.
I have no questions, Chief Justice. Thank you.
Thank you, Chief Justice. I have no questions either.
Yeah. Yes, Chair.
Yes, good afternoon.
Good afternoon.
Yes. What is the test for determining whether a statute or any other law is in conflict with the Constitution?
Before I answer that question, I have to confess that I'm not very clear on it, but my view is that this entails the test of constitutionality, whether the inferior law does not take away the rights which have been provided by the Constitution, thereby, if accepted or upheld, will render the Constitution ineffectual. Thank you, Madam.
That's your answer?
That's my attempt, ma'am.
That's all? That's as far as your attempt goes?
Thank you, ma'am. Correct.
Very well. Thank you.
Thank you, CJ. My question would be, in your experience as a judicial officer, does performance management have a bearing on judicial independence? Maybe just give me an explanation for your view.
Thank you, Madam Commissioner. Performance management does not negatively affect my independence as a judicial officer. In any event, it enhances my independence, because the independence of a judicial officer must be enjoyed together with accountability, since we derive our judicial authority from the people or the public and the Constitution, and we have to account for that. So performance management is a mechanism to ensure that we are working towards the achievement of the constitutional goals, thereby does not conflict on independence of the judiciary. In other words, it actually enhances it, as it will be contextualized in the expectations of the public, which repose upon us, the judicial authority, through the Constitution.
Thank you for your response. Thank you, CJ.
You can pass.
Thank you, Chief Justice. Mr. Nduna, good afternoon.
Good afternoon, Madam Commissioner.
Yes. Well, therefore, Mr. Nduna, in terms of value and principles, right, which values and principles do you prioritize in your life, and how do these have a bearing, or how do you align them with your aspiration of being a judge?
Thank you, ma'am. Generally, I'm a reserved individual who works hard, and it is a cardinal requirement that a judicial officer must exert himself on his judicial functions. So my being amenable to hard working will answer to the call of being a judicial officer, which has guided me over the years I've been on the bench, albeit in the magisterial courts. Thank you, ma'am.
Thank you, Chief Justice.
Yeah, thank you.
Yes, thank you, CJ. Mr. Nduna, I mentioned, if you recall, I mentioned that there were other complaints against you. We have a letter, a copy of a letter here, which dates back to 2010, when you were magistrate in Chinhoyi. You recall the matter concerning Patrick John Stokes, a farmer who is said to have resisted eviction from the farm to allow those that had been allocated the farm to move onto the farm. And the allegation is that they sought to have him prosecuted, but the matter failed to take off on 9 different occasions, with the effect that the farmer continued to reside at the farm. And the allegation then that is raised, or that was raised in the letter, was that you yourself were actually residing at a property owned by that same farmer. And I think the suggestion is here that you might have had something to do with the failure of the case against the farmer to take off. What would be your comments?
Thank you, Madam Deputy Chief Justice, for giving me this opportunity to address that complaint. I recall that complaint very well, and I confirm that it was received. But however, at Chinwe during that time, I was the second most senior magistrate at the station after the provincial head, who was seized with administration. So basically all land cases which were very involving at that time were being placed before me at the station. So when that letter was written, it came as a shock to everyone, including myself, because I was staying in Karoi, commuting to Chinoi every day, despite myself being allowed institutional accommodation. And I remember that farm was, I think after Banget, going in the opposite direction to my home. At no stage did I ever spend a night in Banget or a day in Banget other than having gone to Banget on circuit court. So clearly our understanding of that complaint was that it was unnecessarily malicious. It was meant to oust me from holding that particular trial, as I had generated a reputation for myself to effectively deal with those cases which were very involving during that time and were littered with a number of applications which could facilitate postponements. But to then say it was postponed for 9 times, I cannot affirm nor deny that, since it is a very long time. But the bottom line is that that allegation was extremely malicious of me and was made, in my view, and a view which was shared by everybody on the ground in bad faith. Thank you, Madam.
So the complaint having been addressed to the Chief Magistrate and to the AG's office, would you remember what then happened? Did these agencies respond? Did they investigate? What happened? Because all we have is a copy of that letter which is making these allegations against you.
Yeah, that letter, ma'am, thank you very much. It was brought to my attention. I submitted a report, and the provincial head also submitted his report accompanied by other investigations which he conducted. Unfortunately, I was not favored with a copy of that report, neither did I receive a communication from the Chief Magistrate's office at the conclusion reached by that letter. So I took it myself that it had been established that the letter was not made on factual basis.
Yes, thank you.
Thank you. This issue of what really amounts to unjust enrichment against the bank in your favor, didn't you consider it as that it would have an effect of causing disrepute, bring disrepute to the judiciary.
Thank you, Chief Justice. My view, sir, is that in the contract which we had agreed, it would appear as if I got unjust enrichment, but I had also plowed quite a substantial input into the venture on my own side that I also ended up coming out even poorer myself. It was a question of the two parties, the other party having failed to perform, but indeed being embroiled in such disputes as a judicial officer, probably I should have done better, but I was put in a situation where I could not perform in order to defray the loan, because it was intended to be defrayed from the farming inputs, as my salary would have been nowhere to reach that mark.
Yes, thank you. We have reached the end of your interview. You are excused.
Thank you, Chief Justice. Thank you, Honorable Commissioners.